Hello and welcome back to the channel for updates in the Vallow Daybell case for today, June 9th, 2021. Lots to get into today, so let's jump right in. First of all, today is 1 year to the day where a very different scene was before our eyes. Look at the pictures on your screen. This is from Nate Eaton's helicopter, where he flew over Chad's yard the day that they were searching for the children and ultimately discovered their remains buried in Chad's backyard. That was a very traumatic day for everyone involved. This is the 1 year anniversary of the day that we all had to give up that tiny flicker of hope that the children were still alive and safe somewhere. So, on the 1 year anniversary of that, is it not fitting that Chad Daybell was in court today? He had to face the arraignment for the 8 felony charges against him, and prosecutors now have 60 days to decide if they want to pursue the death penalty. Chad did plead not guilty to every charge. Moving on. There was some other news that broke today. First of all, there was a filing with the court on your screen. I will read it now. This is an order of commitment for Lori Vallow Daybell. Let's read it real quick. On March 8th, 2021, the court entered an order for competency evaluation pursuant to IC 18211 in this case. Thereafter, the court and the parties received the completed psychological assessment. Which determined that the defendant is not competent to proceed. The state advised the court that it may contest the findings, and the court scheduled the matter for a hearing on June 16, 2021. On June 4th, 2021, the state filed its withdrawal of contest regarding the 18211. Therefore, having considered the evaluation and there being no objection from the state, the court finds the defendant lacks fitness to proceed in that the defendant is incapable of assisting in the defense of this case, and the court finds that the defendant does lack capacity to make informed decisions about treatment, and the court finds that the defendant is not dangerously mentally ill as defined in IC 66-1305. It is ordered: 1. The proceedings in this case are suspended, except as provided in IC 18212, Section 5 and 6. Number 2, the above-named defendant is committed to the custody of the Director of Idaho Department of Health and Welfare pursuant to Idaho Code 18212 for the care and treatment at an appropriate facility for a period not exceeding 90 days. Number 3, the Fremont County Sheriff shall transport the defendant to and from the facility. Number 4, an evaluation of the defendant's mental condition shall be performed at the time of the defendant's admission to the facility, and that a progress report shall be prepared on the defendant's mental condition. This progress report shall include an opinion as to whether the defendant is fit to proceed, or if not, whether there is a substantial probability the defendant will be fit to proceed within the foreseeable future. If at any time the director of the facility to which the defendant is committed determines that the defendant is fit to proceed, such determination shall be reported immediately to the court. Number 6. If during a commitment under this order, a defendant who has the capacity to make informed decisions about treatment refuses any and all treatment or the only treatment available to restore competency for trial, the director of the facility shall immediately report such refusal to the court. Number 7. Each report shall be filed in triplicate with the clerk of the court, who shall have copies delivered to the prosecutor and the defense counsel of record. Number 8. If defendant escapes from custody during his or her confinement, the director shall immediately notify this court, the prosecuting attorney, and the sheriff. So, there you go. She is going to be committed to a mental health care facility to undergo treatment with the goal of restoring her competency so she can get back to court. So we should get an update anywhere between now and 90 days from now, depending on what they find from her in that facility. The facility that she will be sent to has not been released publicly yet, although a lot of people speculate it's going to be Blackfoot. It's possible. As soon as we know, we'll know. Moving on, one more bit of news today, and I have to admit this one made me chuckle a little bit. This was filed by Mark Means. Declared motion to show cause regarding contempt for failure to comply with lawfully served subpoena. Let's read it. Comes now the defendant, Miss Lori Daybell, and moves this court pursuant to Idaho Criminal Rule 17 and all other applicable rules, laws, or statutes to order the state witness, Ms. Melanie Gibb, hereafter Ms. Gibb, to show cause as to why she should not be held in contempt for failure to comply with the lawfully served subpoena. Now, I'm going to stop right there. A lot of people, including myself, saw that, wait, what do you mean should not be held? It's a little confusing, and I was confused by this too. What he's saying to the court is Melanie Gibb has to be compelled to come to court and say why she shouldn't be held in contempt. Because she should be. So Melanie has to prove to the court why she should not be held in contempt, because clearly she failed to comply with the subpoena. So, to date, no response whatsoever has been received by Ms. Gibb and or by a legal representative of Ms. Gibb. At the time of service, Ms. Gibb stated she would refuse service and was calling Prosecutor Wood. Going on, Ms. Gibb was lawfully served with the attached subpoena while Ms. Gibb was physically present in the state of Idaho and allowed ample time to comply with said subpoena. Ms. Gibb has chosen to ignore the rules of law and as such should be ordered by the court to show cause as to why she should not be held in contempt. Any such order by this court should be drafted to allow out-of-state service regarding said order, as Ms. Gibb is believed to be a resident of the state of Arizona, possibly Utah. The defense believes that Ms. Gibb has possibly evaded criminal prosecution regarding incidents relevant to that above case, has engaged in inappropriate private communications, including phone calls, emails, and text messages with the above said prosecution, and has made multiple conflicting statements regarding her personal knowledge, actions, inactions, that should be one word, in regard to the above case, and compliance with the subpoena is the first initial step to address these concerns. The defendant further moves this court for an award of fees, costs, and sanctions as allowed by law in addressing this contempt behavior by Ms. Gibb. Melanie Gibb did not, in fact, answer her subpoena or even have a lawyer file a motion to quash or anything. She just threw it in her hotel room and said, I don't care. So, probably not the best thing she could have done. So, there you go. Maybe we're going to hear more about this from the court and from Ms. Gibb. So stay tuned for that. But that's all the news there is right this minute. Certainly a lot to take in for today. If you'd like to see Chad's arraignment, we did cover it in a live stream earlier today. Go ahead and have a watch of that. We talk about some news in the case. We watched Chad and his appearance. There were family present in the courtroom, and that was just a tough day. A really good step forward in the march for justice, but still really tough overall to handle seeing this guy just sitting there like nothing's wrong. So that's all the news for today. I will see you tomorrow night at 7 p.m. live for the Narcissism Discussion live stream group. That is for all channel members and Patreons, so join us. Tomorrow night we're going to have a new challenge that we're starting, a really cool thing. So join us and we'll see you there with Jess Nelson. As soon as there's more news in the case, I will bring it to you and I'll talk to you soon. Bye for now.